Application number 52/2024, Katanga versus Uganda.
Section 15 subsection 3 of the Trial and Indictments Act defines exceptional circumstances as follows: grave illness certified by a medical officer of the prison or other institution or place where the accused is detained as being incapable of adequate medical treatment while the accused is in custody. 2, a certificate of no objection when the director of public prosecution is or infancy or advanced age of the accused. From the reading of section 15 subsection 3(1) of the Trial and Indictments Act, the only medical officer who is authorized to examine an accused person for purposes of securing bail under exceptional circumstances is a medical officer of the prison or place where the accused person is detained. Again, this one, we refer to the case of Honorable Francis versus Uganda. Section 15 subsection 3(1) of the Trial and Indictments Act defines grave illness as an illness that is incapable of adequate be satisfied that the prison's medical facilities are incapable of treating or managing the accused's illness with positive outcomes consistent with existing medical standards. The first report in relation to the applicant's condition is marked Annexure A1 and is signed by A1 Dr. Patrick Sekimpi. It is dated 13th of November 2023. The other report on record is as of the 3rd of January and is signed by A1 Dr. Joel Chiriabwire. All these reports are from CKIHK Hospital. The purpose of the above reports was to assess the applicant's ability to record a statement as shown by the correspondences. The other report on record is a discharge summary and is dated the 24th of January 2024. There is also evidence that the applicant's counsel requested for a comprehensive medical examination of the applicant by the prison's authorities for purposes of applying for bail, and the prison's authorities responded by forwarding the letter to Mulago Referral Hospital. Indeed, the examination was carried out by a team of specialists from Mulago Hospital. The said report is dated the 8th of February 2024. While the report contains various observations with respect to her health and condition, it falls short of stating whether the condition will not be managed in prison. The law is clear. The only medical officer who is authorized to examine an accused person for purposes of securing bail under exceptional circumstances is the medical officer of the prison or place where the accused person is detained. Further, the medical officer must certify that the condition of the accused person cannot be managed in prison. I perused all the medical reports on record, and there is no such evidence. Accordingly, the absence of any certification from the prison is that her condition is grave and cannot be managed while she is in prison. This ground cannot succeed. On the question of advanced age means the person who is 60 years of age and above. See Rule 4 of the Constitution, Bureau Guidelines for Courts of Judicature Practice Directions of 2022. The applicant's age is stated to be 55 years. As per the rules, it cannot be said that she is of advanced age. It is important to consider whether it is in the interest of justice to grant the application. The court must weigh the gravity of the alleged offense and all other factors of the case. In the application, the applicant has already been committed for trial. The matter has also been fixed for trial. The court does not envisage any likelihood of delay. Though the sureties in this case appeared substantial, the above findings dispense with the need for them in the matter. Having considered all the circumstances of this case, and in view of all the foregoing, it is my view, considered view, that the application for bail is denied. The ends of justice would instead be served by hearing the main case. Accordingly, the application for bail is dismissed. Since the case has been already fixed for trial, the parties are advised to prepare for the trial. I so find.
No, I have no words. I'm so grateful. I thank God. We serve a mighty God. It's the supreme judge we serve. I have no words. I just glorify his name. Because the judge, I don't know. I don't know the judge. I know the supreme judge, the God.
But not merely releasing her when there are those grave allegations. No, omulamuzi asaze bulungi kubanga yatadde mu nkola ndowooza n'ebiteekateeko by'abantu amateeka kyegogera ate ne interest za omuwawaabirwa n'agamba nti omuwawaabirwa interest ze ziri served by okuwulira omusango ogwo mangu n'olwekyo seteri date y'okuwulira omusango. Ekyokubiri n'agamba nti abantu public mu Luganda public ki abantu balina endowooza yaabwe. Omusango guno gwamaanyi bwe guti tomulagalekula muntu okujjako ng'omutrayinze n'olaba nti teyakikola n'olwekyo okusasifayinga endowooza z'abantu nanga nti abeereyo okusabinga interest of just trial ebeere mangu nnyo bw'abanga tiyaza musango bwamute wanga yaguza.
Council yogera ki kukyokubeera nga hearing again atandika nga gwali ku state watching brief. What can you say? Are you people set? Your team, are you set?
The DPP is set. I am sure the DPP is set. The evidence is there to the best of my information. Ubujuzi bwe buli bari ready, turi ready ogenda maaso n'omusango katugende mu maaso n'omusango oguwulirwe bw'abanga teyaza musango bamute fenna tusanyuke bw'abanga yaguza bamusibe fenna tusanyuke.